So if you look at that fairly direct, specific statement that he had the financing secured, and then you look at what he posted yesterday, at least to my eye, there's something of a disagreement between the two, because he's now exploring things with different advisors and things. It didn't sound like he was exploring things last week.
I agree with you. It clearly seems as though he does not, in fact, have funding secured, and so his blog makes that obvious. And his blog also makes obvious that the tender offer that he was saying that he was going to put forward didn't actually take place. So, and whether or not it's reasonable for him to believe he has the means to have the funding to take place, that's another issue too. So I think it was good that he started to discuss the fact that his tweets weren't accurate, and it's good that he started to really bring clarity to the market. But it's clear that he didn't have the funding secured.
And what are the consequences potentially of that tweet? Because yes, now he's starting to say, well, I'm working on it, but several days passed and a fair amount of trading went on in the marketplace, including the stock shooting up and then settling back down again.
Well, he's still subject to the same ramifications that we initially thought that he could be. Making an untrue statement when you don't have a reasonable basis, and that's going to impact the securities markets, and people are going to rely on that, that is still a violation of the anti-fraud rules. And in addition, making any kind of a statement as to a tender offer and whether or not you believe that you're going to actually follow through with the tender offer, that's another violation. And so his violations are still piled up, but he has come to a point where hopefully now they're going to stop. And he has sophisticated advisors in place now, so hopefully we'll see this moving forward in a more customary and usual manner.
So, Teresa, in a public company, if in fact the CEO, chairman and CEO, started to have some discussions with shareholders about possibly taking it private, at what point does the obligation to disclose that to the world kick in?
Generally, this doesn't happen for a long time because there has to be more certainty. And you don't want to disclose things to the market, obviously, that are going to affect it the way that this tweet did. And so the ramifications of not having full information out there, not having a good idea of whether or not the acquisition would actually take place. Like here, we're talking about Saudi Arabia, which could have CFIUS concerns, regulatory scrutiny. And so it's very uncertain whether or not this would actually go forward and whether or not it would pass muster with other regulators. And so the point at which you generally go forward with shareholders and you make full disclosure is much later when you have more certainty. And there's also some issues as to, whether or not he talked to shareholders earlier. And so it says that he spoke to the board on the 2nd, and then it wasn't for another nearly week that he issued the tweet. And so did he talk to the large shareholders before then? What did they say? Were they not on board? Is that why he tried to go to the tweet? So, I mean, there's still so many questions about the way that he did do this, but this is generally not the way that you would go forward, and it's not a recommended way of trying to reach shareholders.
And Teresa, if there is legal liability here, we don't know if there is, but if there is, how much of it is on Elon Musk personally, and how much would be shared by the corporation, and for that matter, by the board?
That's a really interesting question, because the way that they're doing this communication really muddies the waters. And so you have him in this tweet that he says is personal, but they've also the company has issued in a prior statement that the CEO could use his Twitter account for disclosing material information to shareholders. And so then his personal Twitter account becomes also a venue for him to disclose information regarding the company, which makes his Twitter account subject to the securities laws. But on the flip side, they don't disclose that enough, and so they don't regularly say he's going to use his Twitter account. And so whether or not this would be a disclosure for the company for Reg FD purposes is a different issue. I personally don't think that this would be recognized as adequate disclosure for the company, but I believe that his Twitter feed is still subject to the securities laws because of those disclosures and because of the fact that he does tweet it as the CEO. He has fiduciary duties to the company. So he'll have personal liability, but then also the company in having its disclosure that they're going to use the Twitter feed, also posting this blog on the website. And you don't generally have the bidder of a tender offer being able to post their intentions and explanations like this on the company website. So they're really muddying the waters here as to what is on behalf of the company and what is on behalf of him. And I think that there's liability for both.